What I have for you today is a court decision from the Netherlands about the attempt of a taxpayer to migrate a company from Holland to Malta, which ultimately did not work. So let's see what happened. The structure, I assume, in the beginning was Mr. H as husband, lived in Holland, held the taxpayer, and the taxpayer had a group, taxpayer opcos. Now, this is a typical structure where you have a Dutch entrepreneur who runs a very successful business, or it seems like that, and then when they retire, they turn all the business into assets and they do asset management, but they also don't want to pay tax in Holland anymore, and they want to find a cheaper tax residence for their companies and for themselves. So in this particular case, you get the litigated structure, and Mr. H and Mrs. W have now moved from Holland to Belgium. Mr. H has a Luxembourg holding company which is transparent for some reason, and the taxpayer has moved from Holland to Malta. There's also another company involved called CNV, and to be honest, the facts of the case are quite complex, and the judge refers to A, B, C, D, and F, and so on, and not saying where, who is. So I may get some of the facts wrong, but the crux of the case will still come clear. But this was the structure, and then there was for many years a Dutch tax advising firm, and the documents refer to PwC a number of times, so I refer that this was the PwC firm, and they had a long-term advisor who was the manager of the taxpayer until the 10th of November 2011. And then from the 11th of November or 10th of November, a Maltese trust company with Mr. A became the manager of the taxpayer, and possibly CNV, which is another company which mentioned a couple of times as well. And in other words, the taxpayer moved from Holland to Malta at that time and was going to be, or the idea was that it'll be a tax resident in Malta and not in Holland anymore going forward. But that is where things go wrong. As I said, the taxpayer's opcos were changed for an investment portfolio, and the investment portfolio was run by an asset management group in Switzerland who had an asset management agreement. And then we had another partner of, let's say, PwC in Holland, or an employee, but also referred to as authorized representative number one in the case. So this was the litigated structure. And then finally, there were two agreements in place with the Maltese Trust Company, one between the taxpayer and the Maltese company being a management agreement, and another one called the Principal Party Agreement, which I'm not sure whether it was with Luxolco or with Mr. H, but that was the agreement for the shareholder of the taxpayer saying, you will manage my company for me, and we will have a look at those in a bit. If you look at the assessments, or at least that were made, then in 2012, so when the company was in Malta already, or supposedly was in Malta, the Dutch tax inspector said, no, you're taxable in Holland and you have a taxable income of 310,000 euros. For 2013, it was much higher. It was 2.7 million euros, and a dividend withholding tax assessment for 3.7 million, which relates to a dividend of, I believe it was 20 million or 25 million euros. And then in 2015, there is a taxable income of 301,000 euros, which is interesting because the facts of the case mentioned that there was a big corporate reorganization in 2015, where it seems that CNV and the taxpayer were basically taken out of the picture, and they incorporated two, I believe, Curacao companies, which migrated to Malta as well, and which then held, I assume, the assets which were held before by the taxpayer and or CNV. Well, I mention this because I don't understand the background for the high corporate taxable income in 2013 of 2.7 million, and it's not mentioned what triggered that. So if we now look at the court findings, the court describes a whole series of facts, very confusing, very complex, because again we refer to peoples as A, B, and C, and sometimes more numbers, and the same for companies, without, for instance, calling them something like Dutch advisor, Maltese director, Swiss asset manager, or something like that. But this is what seems to happen. The inspector brought forward that in the concluded principal party agreement and management agreement, the trust office, trust group, is in fact almost entirely indemnified from regular liabilities belonging to a director. In the court's opinion, this provides a strong indication that the statutory board did not operate independently and did not bear final responsibility. And this happens so often, right? You see trust companies managing other companies and having huge indemnity clauses for doing the management, because they basically have to tell what they've done. That is how it works in practice. And the court picks this up, and the inspector, and says, well, if you only do what you're being told to do, then you're not the manager. In other words, the management is not where the trust company is in Malta. The management is wherever the people are who instructs the trust company. That's the gist of this. And if we look at the clauses, the principal party agreement, so this was the agreement between the Maltese trust company and the shareholder of the taxpayer. Presumably this was Mr. H. And paragraph 3.1 says the principal hereby agrees to fully indemnify and hold harmless C Limited and or its employees, this was the Maltese trust company, from any and all liabilities in connection with the performance by C Limited of duties and rendering of services pursuant to and in relation to the management agreement or this agreement. And the management agreement is the agreement between the Maltese trust company and the taxpayer, that the Maltese trust company will manage the taxpayer. And then if you look at 2.8, the management agreement, so this was the previous one was the principal agreement with the shareholder, now the management agreement with the company that's being managed itself, liability and indemnification. 5.1, C Limited or its employees, the Maltese trust company, in other words, the directors and any affiliates of C Limited shall not be liable for any direct and or indirect damages incurred arising out of or in connection with the services performed by C Limited. Now, it's very difficult to say that you are a responsible manager if the first thing that you do is you write that I have no responsibility whatsoever. And that's what the court picked up on. And then the tax inspector went on and he provided insight into the actual course of events regarding the board meeting of 10 July 2015. And this is quite a funny one, right? Because if you're going to set up the structures, get your timing and your logistics right? So we're talking about the board meeting of 10 July 2015, in which several board decisions were allegedly made on Malta by the statutory board, C2.5 to 15 to 22, that describes the facts. The court observes that according to the email correspondence, the documentation including the board decisions were prepared and drafted by employees of, we assume, PwC working at in the Netherlands. In the drafted minutes of the meeting were attached to an email sent on 10 July 2015 at 20 to 12. However, the meeting in Malta on the same day was not scheduled until late afternoon, and at the time the meeting were held, taxpayer agent 1 had not yet landed in Malta, so this was a PwC partner, I assume. The court sees in this an indication that, in fact, the decisions were taken in the Netherlands and then formally ratified in Malta by signing the document, right? So they made the minutes, they'd already determined everything that was decided, emailed that in the morning of the 10th to the Maltese trust company. Then everyone flew in the afternoon, landed, had the meeting, quote unquote, in which they signed the minutes that were already prepared for in that morning, right? So you can see here in 222, that's part of the facts that they refer to. On 10 July 2015, 11:39, an employee of the trust group sent an email to MAF. Thank you for your prompt reply and comments. Please find attached the amended minutes complete with your suggestions. This email includes the minutes of the board meeting dated 10 July 2015, and it states as relevant, okay, the minutes of the meeting of CNV, and then etc. Resident in Malta, not, right? And the court then goes on to say, there's also the state of affairs regarding the agreement with CHCO, right? So this is the Swiss asset manager. That agreement concerns the management of a substantial part of the taxpayers' assets. The tax inspector stated that on 10 November 2011, the taxpayers' statutory management, in other words, the Maltese company, would have confirmed this agreement going forward, while the Maltese company did not have access to the agreement. So they confirmed the agreement applies, but they have no idea what the agreement says, right? The court notes that the statutory board ratified this agreement on 10 November 2011, but no document shows that the Maltese director had a copy of the agreement prior to 2013, in other words, 2 years later. Not good. And then the court goes on to say, thereby in the court's view, the other communication with CHCO provide further insight into the actual course of events regarding the taking of court decisions in respect of the taxpayer. The court observes that in an email of CHCO on 15 September 2015, the statutory board does not provide any substantive answers to questions regarding the restructuring of the taxpayers, but notes that the restructuring was proposed by PwC. And then they quote another instance where, you know, the management of the taxpayer gets asked, well, how does this work? How does that work? And they say, well, have a look at the PwC memo. We don't know, right? Because the whole restructure that happened in 2015 was set up by PwC in the Netherlands. And the Maltese directors, I mean, they one of the other points of the court is that they received very little money for their services. I think it was less than 10,000 euros a year. So the court then goes on, and this is what I'm talking about. The inspector additionally argued that the statutory board spent only 15 to 19 hours, and this is a Maltese board, right, per year on the taxpayer. Other than signatures on several documents, the court sees no concrete evidence in the very voluminous file that these hours were spent making core decisions. The court also includes in its judgment the extent of the director's very limited time records, 15 to 19 hours annually, and the amount of remuneration, I apologize, not 10,000 euros, but 2,500 euros. In the court's view, such low remuneration combined with such timekeeping is further indication of the court's conclusion that the Maltese company had no idea of what was going on. The court notes that several assertions and arguments have been put forward on behalf of the taxpayer in response to the above-mentioned points. In other words, that the Maltese company was doing nothing. But that almost none of the assertions have been accompanied by concrete, verifiable documentation showing that the Maltese director did more than administer, attend certain telephone meetings, prepare annual accounts, and sign the documents. And this is a problem with trust companies, right? They should not be making any substantial decisions because that's not what they hired for. But a company is resident where the substantial decisions are made. And these were not made by the Maltese company. It was simply giving a paper address, making the accounts, which for 2,500 euros a year is very, very cheap, and signing documents upon request. So the court then concludes, it further follows from the file that the Dutch tax partner and B, another employee of I assume PwC again, had a steering role in relation to the taxpayer. The court refers to the communication recorded at 2:15 all the way through 2:30. On the basis of the above facts and circumstances considered together, the court finds that the inspector made it plausible that the actual management of the taxpayer was in the Netherlands exercised by Mr. Tax Partner and B. On that basis, on the basis of the tiebreaker in the Maltese-Dutch treaty, this leads to the conclusion that the taxpayer was domiciled in the Netherlands. And with that, the taxpayer lost the case on corporate migration. Now there are further food for thought, right? One thing is how would this decision pan out in the new Article 4.3, where you don't go to place of effective management, but the competent authorities must decide where the company is resident. I assume it would still have been the same, because I don't think the Maltese competent authority would have argued that the company was really resident in Malta. And the second one is Luxco was a hybrid company. And I wonder why this didn't feature more in the case, because the payment went from a Dutch company not resident in Malta through the Luxembourg entity up to Mr. and Mrs. H and W, which were resident in Belgium. And I think from a Dutch point of view, the argument simply is, if we treat Luxco as a holdco, as transparent for some tax purposes, we need to treat it as transparent for all tax purposes. So we also need to treat it as transparent for dividend withholding tax purposes, and therefore we look through it and we see the Belgian tax residents, because remember, Mr. H and Mrs. W moved to Belgium. I hope you enjoyed this case. I look forward to discussing another one with you next time. I think this was factually complex, but ultimately rather simple, and it serves as a warning in terms of corporate migration and aggressive tax planning like that, in the sense of make sure you've got real substance where your new management is, and also make sure that your email correspondence and everything else adds up as well. Don't send an email with minutes of a meeting that was held when people have not landed to have the meeting yet. Bye for now.